Institute. He works in fields such as information privacy, intellectual property, media regulation, internet freedom. Been in a lot of media outlets, including Reason Magazine's Hit and Run, Cavuto on Fox Business. Got an undergraduate degree in economics from Northwestern University. He's a JD candidate at GW University here in town. That leads me to be introduced. I'm Pete Sepp, Executive Vice President, National Taxpayers Union. My job there is to know next to nothing about everything we do, which is why we have these two guys here as the experts. We can start off, I think, just with a couple of housekeeping rules here. Feel free if during this course of discussion there's something you need clarification on, like we're starting to use acronyms and you have a question of what it means, feel free to jump in. No worries about that, but if you have sort of a substantive policy question, let's try to hold those until the end. Also, you may want to stay here after this panel because another National Taxpayers Union panel is coming up that deals with the subject of internet taxation and e-commerce, which is something we've worked on a great deal. That fellow in the gray suit there, Andrew Moylan, will be leading that panel, so be sure to stick around for that. Let's start out this discussion with an acronym, SOPA. Which really needs no explanation to most of you. Stop Online Piracy Act. Lots of controversy over things like trademarks and copyrights, Hollywood versus the little guy, but at its base, there are many other important issues surrounding this legislation and the subsequent grassroots movement that rose up to defeat it, chiefly having to do with government's role in overregulating the internet. So, Ryan, your thoughts on this?
Should try to stand up here or just sit down and sit? Okay.
Yeah.
So we were just complimenting you and your lovely voice, the best voice in the movement, we thought.
That's about it. I got nothing else. No brains.
So SOPA is a complicated issue. It rests on another even more complicated issue. What sort of intellectual property laws, if any, we should have. We could have a long discussion about the nature of copyrights. Hopefully it would end in like a fist fight or throwing things at each other.
Usually does.
Usually does, libertarians and intellectual property. So let's just sort of take it as true that for purposes of this discussion, copyright has some value and that it is a legitimate role of government. Which of course is debatable, but taking that as true, the question is, what do we do about it? How do we enforce it? What are the trade-offs at stake? The challenge with SOPA was that it was an overreach. It would have probably done at least something to reduce infringement of copyrights, but it would have also raised huge challenges for internet security, for small startups, including foreign startups, and it would have given rights holders or holders of copyrights and trademarks excessive legal leeway to shut down law-abiding websites. So this fight was really about whether we can have an open and free internet that coexists with vigorous and robust copyright enforcement. What I think we've learned from the SOPA debacle is that those are two very difficult realities to meld with each other. That as long as we have a largely free and unregulated internet, there are going to be a lot of bad guys out there. That doesn't mean we shouldn't do anything about them, but we should be prudent and careful and worried about unintended consequences whenever we're regulating or legislating an area. So we could get into the details of what the legislative problems with SOPA were. Perhaps the biggest concern to me was that the definition of a website that could be seized was a site that is used in any manner or part to commit or facilitate the commission of criminal copyright infringement. Which, first, that includes virtually every website out there that has user-generated content. One link, perhaps, could be criminal copyright infringement. One YouTube video. So here in the United States, we have this entire legal regime governing what's called intermediary liability. It's what protects websites like YouTube, Twitter, Facebook, user-generated websites from liability. And one of the core principles is that a website shouldn't be liable for what its users do, except in certain cases. So there's a safe harbor. SOPA would have flipped this on its head and essentially imposed a de facto duty on websites to ensure that there was no illegal infringing content, which of course is a crushing burden for any website in this day and age.
So what do you think about the Open Act as an alternative to this? Could you describe that?
Before we do that, let me just unpack something Ryan said just for 1 minute, because this is really fundamentally important to understanding the field. So Ryan touched on, he used the terms intermediary liability and safe harbor. You should know, as background, that we have 2 laws in the U.S. From the late 90s that create these intermediary immunities for tort law, essentially everything but criminal and copyright. Section 230 says if you host third-party content, you are not liable for it, period. Which is the only reason, really, that sites are able to do that. Otherwise, they would have to police all that content. Or if somebody complained to them, they would be put in the impossible situation of having to determine whether something is, let's say, defamatory, and would instead probably just take it down. The second law that Ryan was referring to, that SOPA, and this is the one that SOPA would have really, in a sense, overturned, is the law that takes that principle for copyright and applies it slightly differently and says, this is the Digital Millennium Copyright Act, you have immunity, but if somebody sends you a proper notice saying that, for instance, their song has been uploaded to YouTube in a video, then you have to take it down. That's a notice and takedown system. And without getting into too much detail, those 2 things have been really the bedrock of how the internet has been allowed to flourish over the last 14 years, and it is SOPA that would have changed those. And so to Pete's question, the Open Act would in a sense, not have touched those in as dramatic a fashion. This is Darrell Ison's compromise bill. And it would instead have said, let's deal with the problem of rogue websites the same way we deal with international trade problems, which is, let's go to the International Trade Commission, which is an agency of the U.S. government, and let's have a semi-judicial process, so an administrative law judge that would deal with those things there. And the idea was this would have, it wouldn't touch the architecture of the internet at all, which the original draft of SOPA would have done, and it would have had a more balanced process for weighing complaints.
So again, this is all coming back to the fact that we're talking about government interaction and regulation with the internet, not just interaction over copyrights and intellectual property.
Yeah, and just to tie this into what I mentioned before about the really big picture here, one of the reasons we don't have more allies in this fight is that many people who go into this issue get obsessed with copyright and they go down that rabbit hole and they never come out. And so what we're here today to do is to give you a sense of the breadth of issues here, of which copyright is one, but what Pete is getting at is that it's just an example of what I think is 2 fundamental questions. One is, what is the standard for deciding when government needs to jump in and in some sense regulate the internet or do something more than it has done in the past? And how should it do that? And here, that standard the bar was set pretty low. The copyright holders basically said, there's a problem, we need this draconian solution, let's do it. The second question is, whatever the proposal is, what is the process by which it should be evaluated, and what is the role for expert testimony to inform Congress' decision about the unintended consequences of what they're doing? And so in both senses, I think SOPA was a problem, the Open Act was better, and I would just try to ground all of this for you in saying that to us, I think I can speak for Ryan here, this is really a great example of what Hayek was getting at when he said that in general, it was the curious task of economics, and he's laughing because I use this in every panel, to demonstrate to men how little they understand about what they imagine they can design. And that is no more true anywhere than it is for internet policy, because technology policy is such a series of complicated technical, practical business challenges. You put your thumb down on one area and you're going to have unintended consequences in another area.
I briefly want to build on that. This relates to a really important theme about internet freedom and tech policy in general. This is I'm borrowing this from Adam Thier of the Mercatus Center, who's one of the great minds in technology policy. His point is, looking at the copyright issue as a case study, but all the issues, that everybody has a pet problem with the internet. The internet is bad for, there's
Santorum.
They're right. There's too much Santorum spreading, there's defamation, your information is being taken, your copyrights are being infringed, your terrorists have websites and forums to communicate. Everybody, or just about everybody, has something about the internet they don't like, and they're going to turn naturally to the government and try to get a solution. But Theo's point, which is correct based on what we've seen to date, is everybody's going to be disappointed because putting the genie back in the bottle and trying to get bad things off the net is virtually impossible.
And e-commerce is one of the same things. It's untaxed supposedly, and that's a whole other topic.
And the other core point to make there is that making an exception in one area to the general hands-off-the-net rule sets a precedent for every other area, which is why we are consistent cyber libertarians.
Well, now, NTU didn't really do much. My organization didn't do a whole lot in SOPA. There's another topic we ought to get to here concerning government threats to privacy. We often hear of government providing guarantees of privacy, but there's a whole area of internet governance here that many people are concerned about. Recently, this Jones decision in the Supreme Court has federal regulators, probably the gears in their heads are suddenly grinding even faster, figuring out another way that they might be able to somehow work more government impingement on information over the internet.
So let me say, we're going to talk about privacy, and this may be repetitive for those of you who went to Jim Harper's talk this morning, but it'll probably be better. So just briefly, so remember we do technology policy writ large, not just internet policy. So this is a great example where you can't just limit the issue to the internet. So very briefly, the Supreme Court, anybody here familiar with the Jones case? Anyone? Show of hands. Will Reinhardt, ladies and gentlemen, my colleague in the back there. That's good, we got a plan. So anyway, very briefly, the Jones case was concerned whether government could, without triggering the Fourth Amendment, which, let's just say, generally speaking, requires that when there's a search, you have to get a warrant from a judge. You have to show probable cause, right? So the question is, when is the Fourth Amendment triggered? And in that case, government law enforcement, more specifically DC police actually, planted a GPS tracking device on an alleged drug dealer's car, and were using that to monitor his whereabouts over an extended period. And in a nutshell, the court did exactly what, I have to say, I told everybody they were going to do, which is they didn't really address the bigger picture issue. They said, we're going to resolve this on narrow grounds, which is that government here the term in archaic Anglo-Saxon law is trespass to chattels. So you got chattels, your stuff, your cows, your whatever, everything but your house, basically. And if the government touches that, impinges on it, that's a trespass. And so that was a really easy way to resolve that decision. It was a surprise to some people because there were some people in this country who don't think about property rights, like our friends on the left, who are generally pretty good on civil liberties, were a little surprised that the court resorted to a property rights-based approach, but it's really not very surprising. The court said, this is the bedrock of what the Fourth Amendment's about, but it's only the beginning. So that's the basic standard. Does government touch something of your stuff? And then beyond that, the question then becomes, if they do it in a digital way, where there is no physical trespass, which is the kind of case we're going to see more in the future, then the court is a little more unclear about what to do, because under 1967 Katz decision, the standard is a very vague one. It says, what is the reasonable expectation of privacy? And so the key point about this decision is that it's really the beginning of the court starting to grapple with either how to apply that standard in the digital age, or whether that's the right standard at all. And the important thing to understand about this standard is that it is created, this is going to sound kind of wonky, but what's called the third-party doctrine, which is a huge problem for everyone in this room. Because it means that if I have a piece of paper, it's protected by the Fourth Amendment. It's in my desk, it's protected. If I give it to my attorney, it's protected. But if I give it to one of you, it's not, because you're a third party and the government doesn't recognize that there's any expectation once you give it to somebody who doesn't have a privileged relationship like a spouse or an accountant or an attorney. And so the point of that is that on the internet, your email is protected if it's on your computer, but if it sits in Gmail's servers, it's not protected at all by the Fourth Amendment. That's right. And so in 1986, the Congress passed a law, which is what Ryan is alluding to here, that was attempted to fill that gap, called the Electronic Communications Privacy Act, ECPA. And to make a long story short, that act doesn't really work today. It has these archaic standards about whether an email's been opened, how long it's been there. It doesn't make any sense. And so this decision is really important because Justice Sotomayor joined, all 9 justices agreed that what the government did in that case was a problem. Justice Alito and his 4 justices, including him, said, we'll resolve this on physical trespass grounds, we'll deal with the other bigger questions later. Justice Sotomayor joined, but said, the third-party doctrine is a huge honking problem because it means all these files, everything that we do on the internet, doesn't have Fourth Amendment protection. And it's left up to these statutes that don't really work. And then the remaining 4 justices, excuse me, I said Justice Alito before, I meant to say Justice Scalia. The other 4 justices, led by Justice Alito, said Congress needs to fix this problem, Congress needs to update ECPA. And so this is really an introduction to a larger fight that we're having now about how to limit government's access to information. And in a nutshell, our argument is that the Fourth Amendment standard is the right one. That's a way to balance liberty and order, privacy and security by saying, yes, law enforcement can get access to information, but when they do so, generally speaking, they should go to a judge, and the judge should be convinced that there's probable cause, and the judge should issue a warrant. And that really, in a nutshell, is the single biggest reason why our forefathers fought the American Revolution, to protest against the British use of warrants that they were just issuing themselves without any probable cause to search our homes and our prisons.
Yeah, and so there's a growing concern now, for example, that there will be a legislative effort and data retention mandates, those kinds of things.
Sure, well, on one hand, we have folks in government who are trying to protect our privacy, or claim they are, whether it's doing good things, such as reforming ECPA, so an email retains its warrant protection, even if it's 181 days old. Those are positive efforts. On the flip side, many in government are trying to regulate private companies from collecting your information. In many cases, on the ground that if a company collects your information, government might get it. Why legislators would focus on the company when it's the government that they should be worried about, and actually are worried about, is strange. As for the question of data retention, it presents an interesting dichotomy, which is not unique to the United States. On one hand, some lawmakers are trying to give us more privacy. On the other hand, the government is the worst enemy of our privacy, and it's moving in the wrong direction. This data retention bill, which was passed out of the House Judiciary Committee last July.
Same committee, same chairman that pushed through SOPA.
Right.
Very similar fact pattern.
Yes. This bill would require anybody who offers internet access for a fee, which includes not just a provider like Comcast, but even a coffee shop or perhaps a hotel that attaches a purchase of a cup of coffee or a hotel room to an internet connection. This law would say you have to collect data for 6 months and make it available to government about which individual user is tied to which address. The reason government wants this is because this makes it really easy for government to figure out who has done what on the internet. Now, in some cases, this makes it easier to enforce criminal laws when you've identified a wrongdoer and all you have is an IP address, and you know the crime occurred 3 months ago. If you go to the provider and they don't know who the owner of that address was, or the user was,
At that
you're out of
particular
luck.
moment.
At that moment, you're out of luck. On the other hand, being able to tie back an internet address to a user is an excellent way for the government to go after, say, whistleblowers, people who engage in political speech. It really creates a chilling effect where people can't expect what they do on the internet will remain private. Because today, if you go into a Starbucks and hop on the Wi-Fi there, and you take a few other precautions, your laptop is running a Linux live CD or something, you can do things that will almost near complete certainty never be traced back to you, except insofar as there's other evidence of it. And this is a problem that really represents how government continues to threaten our privacy. Fortunately, so far, the House leadership has not taken this bill to a floor vote. But at any time during the remainder of this year, that could happen.
Yeah, your remark about whistleblowers is especially on point. Federal employees actually remain the least protected class of employee in the entire workforce when it comes to anti-retaliation statutes and the like, if they blow the whistle on this fraud and abuse in government, and this only feeds into it, makes it worse.
So we should really just kind of run down the list here because we're apparently running out of time. Right, okay, so anyway, let me just give you 2 quick points that we'll touch on and we can talk about net neutrality. Just so you're aware, there are some other government privacy issues concerning expanding requirements that all internet services become wiretap ready. That is, government goes to them and says, put in a wiretap, and they do it. That's a huge privacy concern. There's another one that's going on right now that's cybersecurity that, without getting into a lot of details, involves the extent to which internet service companies can share information about cybersecurity threats with each other in the government. And that actually is well intentioned, because right now there are other privacy laws that heavily restrict sharing of information when it could really be very important to protect us from real cybersecurity threats. But the proposals that have been put forth thus far, one that was introduced this last week by Senator Lieberman, as you might imagine, go way too far.
And they've got private contracts to make them unenforceable.
Yeah, exactly. We had a long conversation during the break, if you're interested, about privacy regulation of the private sector, which is restricting how private companies can use data. This is just much like copyright. It's another issue where the freedom, the side of freedom becomes a little bit murky. So there are a lot of people who are arguing for regulation there and saying that they're doing it to defend our freedom. We're a little more skeptical. We're skeptical of government regulation in general. We can talk about that in Q&A or after the panel if you like.
Now, one issue that's a little more clear is net neutrality.
Yeah, just briefly, I mean, we're kind of sick of net neutrality, I think it's fair to say, because it's been sucking up all the oxygen in the room now for about 7 years in our space. But fortunately, in some sense, the issue is finally before the courts. The FCC last year finally issued its illegal net neutrality rules without any authority to do so, and Verizon's challenge, and that issue is now before the DC Circuit. The DC Circuit has formally referred to the FCC as it's basically all but called them a rogue agency, and said that they have been unleashed from their tether of congressional authority, which is a nice way of saying, like, you know, what? Yeah, exactly. Forget about it, as we say in Brooklyn. So that fight is going to be resolved by the courts this year. It'll probably eventually go to the Supreme Court. Maybe we'll see. We're on the side of the angels on that one, of course, arguing that there is a free speech and a property rights issue there, and that should be something we should be concerned about. And as in many of these cases, it's not that there is no problem. The question is how you deal with it. So my former think tank, the Progress and Freedom Foundation, our suggestion was we already have a system for dealing with anti-competitive conduct. It is antitrust law. And while we are skeptical about the use of antitrust law as well, we think that's a better standard by which to evaluate net neutrality complaints, and we propose a system for doing just that. So this might...
It's not that we support internet providers discriminating against content or blocking things you like. That's not our vision. In some cases, perhaps speeding up certain content or slowing it down might be a great thing, whether it's gaming or traffic that is time sensitive. Our general vision is that discrimination or preferential treatment is something that's better driven by the market, and the consumers aren't going to want a provider that is doing things that harm the user. So to the extent there's a theoretical problem, there may well be one, but any company could stop offering services or make its services worse. Yeah, we don't have a governmental mandate forcing them to do so. There's just no real problem here that needs to be dealt with.
So again, the question is how you regulate. Do you do it through antitrust, to punish clearly anti-competitive conduct, or do you essentially subject these companies to public utility style regulation that might have been appropriate in the 1880s?
Which brings us to our next topic.
Indeed.
Antitrust. I can talk a little bit about this subject from a position of authority in my 23 plus years at NTU. I was around for several of the high-profile antitrust actions, the ones against Microsoft, Visa, and MasterCard. Also, my organization being about 40 years old and having Milton Friedman on our board of advisors, we were engaged during the 1980s against this whole IBM case. So a lot of history. Interestingly enough, as Barron alluded to, antitrust law began before the turn of the 20th century, 1890 actually, with the Sherman Antitrust Act. A whole bunch of acts followed, the Clayton Act, the Federal Trade Commission Act, and one rather Orwellian named the Seller-Kefauver Anti-Merger Act of 1950. But the Sherman Act bears reading. It's just 2 short sections. Every contract, combination in the form of trust or otherwise, or conspiracy in restraint of commerce among the several states or with foreign nations is hereby declared illegal.
Unless government does it.
Right. Section 2, every person who shall monopolize or attempt to monopolize or conspire with any other person or persons to monopolize any part of the trade or commerce among the several states or with foreign nations shall be guilty of a misdemeanor. You can imagine how much mischief can be made in those words, and it has. This is the most important point to make about antitrust. We read about Teddy Roosevelt and his trust busters and the like in the history books, and how Standard Oil the awful robber baron, J.D. Rockefeller, was brought to his knees as a result of this. But an interesting comment from Professor Dominic Armentano. He said there was no golden age when monopolistic abuse was running rampant in the free market and when, accordingly, antitrust was magnificently relevant. He said, antitrust law has always been ambiguous. The theoretical foundations of antitrust theory have always been faulty, and the empirical evidence has always been non-existent. That's the takeaway from this. It was conceived in politics to begin with. And you can see through antitrust's history, look at all of the arguments that have been made from Standard Oil back in 1911 to today. Oh, this monopoly is raising prices for consumers. The price of a gallon of gasoline dropped 80% between Standard Oil's supposed monopoly and when it was broken up. Consumers were benefiting, and at the time Standard Oil was broken up, it held an 11% share of oil production. Does that sound like a monopoly? Its market share was higher, but its production share was minuscule. Then you move on to other cases like Alcoa Aluminum.
We got to turn to questions.
I know. We've got about 10 more minutes. But the important point to make here, going forward to Microsoft, for example, in the late 1990s, is that antitrust regulators continue to bring up new reasons to become more aggressive in their enforcement. And stock returns tend to suffer as a result. George Bidlingmeyer has done a lot of research on that in periods of heavy antitrust enforcement, stock returns start to go down. There was a fellow actually, and I swear I'll finish up very shortly here. This is kind of tongue-in-cheek, but I think it gets us to a point where we recognize the human consequences of these policies. This is a post by Brian Kaplan called Antitrust Kills. He went up to a website called Frugal Dad, which said that Bill Gates, having given away about 48% of his net worth, $28 billion, has saved almost 6 million lives as a result of his charitable activities, roughly $5,000 per life. This fella calculated that because of the antitrust actions, because of the $140 billion losses to shareholders, perhaps $5 billion of which accrued directly to Bill Gates, as many as 1 million people who could have been helped might have died. Call that tongue-in-cheek, granted, but doesn't that get us to thinking a little bit here? That maybe, just maybe, there's more to this than dry courtroom battles. So, what thoughts do you have here?
I would just add briefly that the great famous economist Ronald Coase once said that when economists see conduct they don't understand, they cry monopoly. In no context is this more true than antitrust. The reason that I'm extremely skeptical of antitrust is not because I believe that it is impossible for a merger or even the conduct of one firm to genuinely harm consumers and be anti-competitive. I think it happens. It's very rare, but it happens. The question is, can we identify and can we do anything about it? The risk of error cost is what we have to keep in mind. That for every bad merger we stop, there are 10 or 100 good mergers that we also stop. And never in history has antitrust been able to identify the needle in the haystack that is anti-competitive conduct, and it likely never will be able to. As such, the proper course is to let markets self-correct rather than resorting to government.
And briefly talk about Google.
So let's just frame this. So you've heard the big picture of antitrust. So the point right now is that, just as Ryan is saying, in high-tech markets, you're dealing with, people often have this idea that innovation is about technology. Innovation really is more than being about technology, it's about business models. It's about how you take a new technology and you apply it and you actually make money off of it. And that is precisely what is so difficult for regulators to understand, especially in the antitrust context. So on Microsoft, on Google, we're skeptical across the board. Google's sort of the whipping boy today for antitrust. There are a number of other antitrust complaints that have been raised. You obviously know that the AT&T T-Mobile deal was derailed because of these concerns. Very briefly, I would just say that in that particular case, It was derailed largely because the FCC was focused on very outdated 1960s style metrics for measuring levels of concentration, which make no sense. And the agency itself had said so in network industries like this. In the case of Google, there are antitrust complaints concerning almost everything that Google does at this point, I think it's fair to say. We don't have time to unpack those fully, but in a nutshell, to me, the biggest question here comes down to this is what Ryan was getting at error costs, and also the nirvana fallacy, which you probably all are familiar with. The question is not whether markets fail, the question is not whether there is market power or even monopoly for a time. The question is, will that power last longer than it would if it were left to be corrected by government versus being fixed by market forces? And in a nutshell, our view is that innovation tends to unseat incumbents and does so better than the market, than intervening in markets will. But I will say, just to speak up for antitrust for just a moment, that although it's easy to pick examples of antitrust overreach, there are examples where antitrust, much like Sir Arthur Conan Doyle's famous Hound of Baskervilles, right? So Sherlock Holmes knows that something has happened, knows that someone committed the crime just because the dog didn't bark. Antitrust best success stories, I think, are exactly when you don't see it working. And as an example of that, I would point to, particularly in the case of Google, Google has gone out of its way to make data portable through the data liberation front, which is a transparent riff on the technology liberation front, which is the group blog that we're on. But in a nutshell, that essentially says that you, the user, can port your data out, whether you're buying advertising from Google or using their Gmail or whatever that other service is. And there's a pretty good argument to be made, maybe Google did it for other reasons, but that's exactly the sort of thing that antitrust law, at its best, should want to encourage because it lowers switching costs. So I would just say that there are things like that that we would point to as being better ways to make competition work that maybe would happen anyway. We don't know whether antitrust is necessary for that.
And in tech, ironically, it seems to be so competitor-driven. I say ironically because many of the complaints against Google are originating from its rivals.
Well, that's not new. That happens in every area of antitrust, and it's worth pointing out that antitrust does have a private right of action with triple damages. So you get a lot of money if you win. And Google, to be fair, has also used antitrust complaints against Microsoft in Europe, for instance, arguing that Internet Explorer was going to dominate the marketplace, which is ridiculous, of course. And so our point is not that any one company is consistent, because of course companies are profit-maximizing enterprises, and they all, unfortunately, eventually try to use government as a tool against their competitors, with the possible exception, maybe of Koch Industries.
Well, questions